House Bill 722 by Mr. Peake, Representative Peake. Members of the committee were working on LC off of LC 297011S. Let me sort of do my best to set the table on it. As we have gone through the last month and a half or so, I guess, on this bill, and through conversations in both within the committee and the House, with members of the other body and with the executive, I find myself, and I think the committee's in a position where really it was last year. It was everyone's sharing the goal of wanting to help these people. I mean, everyone shares that goal, and I think I mentioned it in one of our public hearings on it. And the question is what's the most effective, efficient way that we can go ahead and get this done at this point that will also be enacted. That's a very difficult balance to strike, because you have something a vision for an issue and how you want it to play out, and what you think the right approach is, and then you meet up with some political realities that may not have the same vision that you do, maybe some other members of the General Assembly do, and perhaps not what the executive does, the administration. All of which have to be satisfied, or else we've spent an inordinate amount of time and energy and political capital for the sake of achieving nothing. And that would really be a tragedy, because then we haven't helped anybody. And that's the name of the game, as far as I see it. So, and I remember saying pretty much the same exact thing last year, because this, in this building, politics is the art of the possible. And it became clear to the chair, and to other members as well, I think, that the bill as introduced, while very sincere and very well-meaning in terms of its intent and its goal to help people, politically was not going to be achievable. And it came to the point of having to step back and say, okay, what is it that is achievable that can help people? And I think that's where we are as of this minute, and that's why we have the substitute that we have. It became clear that cultivation and introducing the for-profit piece of cultivation was very problematic in the building. And so we had to find another way. This proposal, and it is a committee substitute to members, the chair's been working with the author very directly, very intensely for the last week on attempting to get to a place that we think has a good chance of being enacted. I can't sit here and say that I've had conversations that, guarantee that, because I haven't. But I think this has a much better shot of enactment than the version beforehand. I know that disappoints some people. I know it does, and I hate the fact that it does. But I also don't want to come out of this process without having a mechanism to help more people. And that's, again, a very difficult balance. And the proposal that you have in front of you, LC 297011S, essentially what has occurred from a 30,000-foot level is that cultivation, the for-profit cultivation, has been eliminated from the bill. What we have done is we have expanded the list of conditions to include, on lines 104 to 113, and you can see them there, autism spectrum disorder. Would you pronounce that for me?
It's EB. We refer to it as EB.
EB, which is a terrible skin condition.
Disease, right.
HIV/AIDS, peripheral neuropathy, Tourette syndrome, and terminal illness. We felt that those were, on line 100 to, in conjunction with Crohn's disease, ulcerative colitis, and irritable bowel syndrome. These were the conditions that it was felt had the most concrete definition to them. There were some that perhaps were broad. Sometimes conditions are necessarily broad. But we felt that in order to be as defined as possible would give the bill, as we did last year, as it happened last year, a better chance of being approved. There was talk on autism spectrum disorder of limiting that. The thinking as to why we left it and did not limit it, but rather left autism in general, is because children will, I don't want to say, but they'll move on that autism spectrum, and they could move in such a direction with such a severity from one area of the autism spectrum to another in such a way that we wouldn't want the bill to limit their treatment if they had a degeneration in their condition, and this was called for. So we wanted to preserve that flexibility as it related to autism. What we have done as well, and this was mentioned in the hearing, it's not unnoticed that mail order is a reality as far as the oil goes. Mail order is occurring. There are certain things that we can do in the area of mail order, certain things as it relates to that law that the state controls, and there are certain things that we don't control as far as federal law goes. I can't tell you how many members I've had who have come up to me and said, I wish the federal government would take action on this because it would allow us more flexibility in what it is that we need to do. And that's a true statement. Ultimately, this is a federal issue. And so we're attempting to affect what we can within our jurisdiction, knowing full well the federal laws are there. It's not lost on us that there has been defunding of federal enforcement as per the omnibus bill that was signed early this year or late last year. That isn't lost on anyone. We're not encouraging conduct. We're not discouraging conduct. We're worrying about what it is that we can control. And so there is a provision that's put into the bill that will provide immunity from criminal liability for the companies who do ship at this point and are shipping as we speak from those companies who are shipping, and that's in Section 4 of the bill. What that will mean in terms of increased shipping, I don't know. I don't know. I can't help but think that provision will perhaps embolden those mail order companies to be more aggressive in their shipments to patients who need it. And then when you have the expanded list, again, having to go through DPH and get the card in conjunction with the regulations promulgated by the Composite Board of Medical Examiners, to me, that represents the best, most efficient, expedient path to helping more people that I believe has a legitimate shot at passing the General Assembly and getting a signature. That is a lot of ifs, but we wanted to be ambitious but realistic at the same time. Be effective, but be realistic. It's a tough balance. So, members, that's essentially what the substitute calls for. We will, council has brought up to me that Section 7 and 8 arguably may be violative of single subject. We've heard that before on other bills. I think out of an abundance of caution, if and when we go to a motion on this today or on Wednesday, depending on the will of the committee, I'll probably ask for us to go ahead and strike Section 7 and 8 just out of an abundance of caution. We would not want to have a challenge to the law, then all of a sudden what could be enacted gets struck down because we violated single subject rule.
And I'd be in full support of that too, Mr. Chairman.
We certainly, I think the DUI per se language as it relates to this bill has a place in our code in conjunction with what we're doing on medical cannabis, but perhaps not in this law and not in this particular bill because of single subject rule and not wanting to throw the dice on that. So, members, I wanted you to know from at a high level, the sub, what the motivation was, how we got to this place, both substantively and politically, frankly. I want to turn it over to the author to hear what he has to say, and then between the two of us, we'll try to answer any questions. I know that there is some technical language from GBI as it relates to chemical. There are some chemical names and composition that has to be vetted through. I couldn't explain that if my life depended on it, but I'm going to rely on Mr. Spejas, who's not with the GBI but has consulted with them to attempt to walk us through if the committee is comfortable with that.
Okay.
To the author.
Thank you, Mr. Chairman. You did a pretty good job of summarizing both the background of this activity of the last couple of weeks and as well as the contents of the substitute. I may add a couple more things for the committees, but if you'll give me the privilege of just a couple of comments. I can't come before you today without saying how disappointed I am that we're not moving forward with cultivation in this bill. Disappointed for a lot of families and citizens that could benefit from that. But because that was the heart of the bill. And in some respects, I feel a little bit like a cast member from The Walking Dead. that I must look like I've been disemboweled here as we go from a 24-page bill down to a 7-page bill. But I also can count. And I also know that if I put a bill before you that doesn't get the necessary votes from this committee and doesn't move forward, as Chairman Golick eloquently said, no one gets helped. And so while this may be a little bit like approaching a fire where there's a family of 6 people inside and you know you can only go in and save 1 or 2, do you still go in and try and save those 1 or 2? Absolutely. And so that's in effect what we're doing with this bill, with the expansion of conditions and the opportunity for more people to participate in the registry and have legal possession of medical cannabis oil here in Georgia. Just for this committee's sake, and if it's the will of the committee and it moves to the floor, I'll say it from the floor as well too. This issue of cultivation of medical cannabis oil in Georgia is not going to go away. Not from me, and if heaven forbid I don't return to this chamber, there will be other folks that will carry this banner, because our citizens have spoken very clearly that they want us to try and find a solution, a safe, regulated solution for medical cannabis cultivation in Georgia. And so while we may be taking steps here, and I'm in support of these steps of moving forward, until we find a solution for access here in Georgia, we really haven't solved the problem for our citizens. And so I just think the committee needs to be prepared. I don't know if Chairman Golick's ready to go through this next year or not, but in the words of Arnold Schwarzenegger, I'll be back.
I have no doubt about that. On the cultivation issue, I appreciate the gentleman's comment on that. Had we even hypothetically passed that version, it would have been years, plural, I think, until necessary mechanics and or regulations that would have inevitably been part of it would have been in place.
That is correct.
And
yes,
there would have been no one really helped in the interim because of it. I would say that in conversations that I've had, and I'm only speaking for myself, and the experiences I've had with other members, I think there isn't a necessarily reflexive negative reaction on cultivation. I think it's when you're dealing with a for-profit industry where there is perhaps some insecurity about enforcement and oversight. But I would be dishonest if I didn't say to you that and within those same conversations, I've heard members speak enthusiastically or potentially enthusiastically about the idea of a state-controlled program operated within some venue of state government, whether it's the university system or the ag department or some other entity, so that there is a controlled environment that will give members a little bit more comfort and security from a public safety standpoint and an enforcement standpoint and an oversight standpoint, while still establishing the foundation for what it is you're trying to achieve. I think where there's a will, there's a way, and if there's anyone that has the will, there's no one actually who I've ever known on an issue has more will than you on a particular issue. I think it's just a way of how you get there and taking realistic steps along the way. Yeah. I don't think this bill precludes that idea, and it's just an idea. Right. This bill doesn't, this substitute doesn't preclude that idea from being considered in the interim, not by a long shot. So we can walk and chew gum at the same time, yeah. And that may be the fallback and the control mechanism, I'll call it. That may be that balance that members, both in this body, the other body, and of course the administration need to have that comfort, and that may be the balance.
Right, and I think you hit the point too that I probably didn't say enough. And there needs to be congressional action. until Congress acts and settles this whole issue from a federal level, we will continue to have a hodgepodge of state laws that are inconsistent and provide challenges as well too. So, Mr. Chairman, only thing I'd add, if I can, on the bill, as you stated, the cultivation piece is eliminated, which was a large part of the bill. There's also no change in THC limit. I know there's been a lot of discussion about that. It remains at 5% maximum THC in the bill. We did add THCA as another cannabinoid that is allowed under Georgia law. This is there is some language in I believe in your folders of an explanation of what THCA is. There are a lot of the families that have had to move to other states have used THCA. It is non-psychoactive. It is the precursor to THC before it is heated. That's the cannabinoid in the plant. But it is still subject to a 5% THC limit as well. So we did add THCA. We removed also in lines 95 to 103 the end stage or severe stage to the existing conditions. We actually did that at the request of Emory University, a group that they actually presented a letter to us. I can read it if you'd like me to, where they said that was really problematic for the physicians, that it was better for them just to have the diagnosis and be able to make the condition, let the doctor make that decision. We also added some cleanup language to the clinical trial language in lines 44 to line 60 and through 73. We also, let's see, in lines,
what was the nature of the cleanup language? I think it would be good to have clarity on that.
I actually defer to
on 44
learned
to
counsel,
63.
Ms. Travis, if that's okay.
I mean, if there's I think here's the bottom line question. The bottom line question is, I understand that sometimes there are strikes and it looks like we're doing something that we're not doing. There's no net substantive effect from what we did last year in this substitute, correct?
Right.
Okay.
During this interim, we read everything that gets passed, and when you look at the language in Title 31, Chapter 51, were inconsistencies with the way we describe the clinical program versus the protocol program versus the research program, and the language didn't match up. And we make notes, and then when we see these language again, we try to fix it if we can. So this is just a fix.
Okay.
She explained it better than I could. And then in lines 117 to 121, we struck the language that required a 1-year eligibility, 1-year residency. Again, we had doctors come to us and saying, hey, you're now coming to me when we certify that this person has lived here for a year. It was problematic for the physicians, and so we've removed that. And then finally, in line 122, we had required in code that the board require physicians to provide quarterly reports for their patients. Again, the physicians came to us and said, hey, this is really problematic and burdensome. Can we back off a little bit? So we've changed that to an annual report that they'd have to provide information. So that's the changes other than what Chairman Golick has already.
Let me call the Vice Chair.
Thank you, Mr. Chair. I too shared the disappointment. I thought we had some room to try to see how far we could go here at the state level. I understand the federal limitation, but let me ask you a question about the program. People who are in the registry in the university system, is there a program studying? Well, let me back up. Now, it's my understanding that the DEA and the FDA has given one license to actually cultivate legally here. That's in the University of Mississippi.
That is
right.
Correct.
Has there been any requests from any of the universities in Georgia trying to get the purified form so that they could do research and provide those to those who are registered in the registry?
From Ole Miss?
Yes.
To my knowledge, I don't know whether universities have reached out to them. I know I have personally reached out to them and chatted with the director of the Ole Miss program and said, is there a program in place for a low THC elevated level of CBD product, and at this current time they do not. They are considering it, and they have discussed that that may be something in the future. But as of right now, I think there are only 4 citizens in the entire country who receive cannabis or marijuana from the Ole Miss program.
And I think you've said this. Were there any requests or attempts made by the university systems in Georgia to be like Ole Miss?
Well, that would have to go through and be approved by the DEA, and at the federal level, I don't know whether they've actually initiated conversations to duplicate what's being done at Ole Miss. I know other states have attempted to say we will set up programs at university systems in our state, and in every single state where that has been attempted, it has been blocked, because at the end of the day, the university involved said they didn't want to risk losing federal funding by being involved with a Schedule I narcotic. And so, sort of my knowledge, when we've tried to go down that path, it hadn't really been a viable option at this time.
Thank you.
Other questions from members of the committee? Mr. Setzler.
Thank you, Mr. Chairman. I wanted to thank Representative Peake for, his doggedness and flexibility, and I've never seen so many substitutes in committee. If you work through these things, trying to listen and work with people. I don't know that I'm, in the same place with you in terms of the end game, but I do want to talk about the particulars of the sub, and hope we can advance the cause for the right reasons. I just had some questions about things I simply don't understand. What's the line 23 and 24? This is a technical question. Maybe it's 21 through 24. It's in the definitions.
What I'm going to do is I'm going to ask Mr. Spehaus to come up and join Mr. Peake, because he can actually is maybe in the best position to go ahead and address that from a new language standpoint.
Okay. And Mr. Chairman, I've just got some questions through the bill. If I could just ask a couple.
Well, do you want to let's hear from him on those definitions?
Yeah, my understanding is that was added at the direction of the district attorneys, and so I think it's.
I think it was a GBI ad, wasn't it?
This is the language that's been requested by the chemists that actually conduct the tests at the lab. Again, I'm not a chemist, but I've been briefed on this. The difference between the THC and the THC acid is how it exists in the plant. The acid, my understanding is what is the material that they find in a growing plant, and that, as Representative Peake said earlier, when it is heated or ingested or a couple or dried, that acid portion of it is removed, then it becomes THC, and that the THC is what has the effect on the body. So the acid,
the psychoactive effect.
Yeah, the psychoactive effect. The acid is more the living plant, and the plant keeps it as an acid, and then it later gets converted. So this language and definition is actually brought over here into Title 12, but it's also in Title 13. And what we're doing is drawing the distinction here of low THC oil, which is the definition that you've gotten from HB1, with the removal of the equal to greater part, which we all agree based on what the crime labs told us that can come out, and then move over the other definition here for THC, which is the Schedule I substance definition. So that's how you draw the distinction. And our current law requires there to be more than 15% weight and it not be plant material to be the definition of THC. This just adds the acid and makes clear that the 15% has to be present and that the sample doesn't include plant material, et cetera, because the plant material, et cetera, is in our marijuana definition.
So how does 5% low THC oil, or low THC oil being 5% by weight, how does that compare to the samples, quote unquote, of being 15% by weight or more? I'm just trying to understand what samples means and what form that applies to.
We've been round and round about the word samples, and we can't come up with a better way to describe it. That's currently in the code. It's in 13. We've just moved it over to 12, and we've got to be able to define to talk about the subject by using a word, and samples is the best one that we can come up with. It's currently
It's in current code now. So yeah.
I'm just trying to understand. I mean, if I,
Right.
you know, I don't expect all my constituents to know this when I talk about this back home, but they certainly expect me to understand what I mean by this or what we mean. And I'm trying to understand. I mean, I think I understand low THC oil, that you've got, you know, a medium, a substrate, or whatever, the oil itself, and you've got the THC in there. You separate it out 5%. I get that. I'm not following what this really means, though. I mean, is this a different thing we're talking about?
It means you've got three different substances that Georgia law addresses related to marijuana.
Okay.
The low THC oil that was created in HB1.
Okay.
THC, which is the current definition over in 13, so where you see it here in Section 2 is just a duplicate of where it's already in Title 13. And then you have marijuana. And, of course, marijuana is what we traditionally know involves the material, the plant, the seed, and what have you. That can be tested in a much different environment than THC once the plant material is removed, and this chemical is what they are actually testing for.
So you've got the plant material. I get that, and I get THC oil. This THC, what you're calling THC, this is a distilled powder, resin. What are we talking about?
Generally, it's a liquid as well, but I mean it could be in other formats. I mean it could be turned into a substance. I don't know exactly what kind of format it gets turned into, but that's why the law currently requires it to be at 15% by weight. So low THC oil, THC, once it gets to 15, and then marijuana. Plant.
So THC at 10%, 12%. What is
not? It's not covered. It's not currently covered.
But what's the distinction between that, an oily kind of thing, versus a low THC oil, which is oil?
The percentage of THC. The low THC oil is the 5%. The THC is the more than 15%. And that's what you're addressing is a gap in current code.
I'm just not clear what it is we're talking about. I mean, I'm not being argumentative. I'm not. This isn't a policy. Yay, no, yay,
My
nay.
understanding is low THC oil and THC could look exactly the same to me and you. It's when they go in and chemically test it and determine the percentage of THC by weight is whether or not it would be low THC oil or it would be THC.
So a substance that's oily and it's got THC in it, if it's determined to be 10%, is it illegal THC oil that's over 5%, or is it legal THC that's under 15%?
It would not be covered by current code.
And in fact, it got posed to me, why don't we just move the THC level to 15% for low THC oil? Because, quite frankly, under 15% is not a violation of Georgia law. Is that right?
Or another way to do it would be to take the THC definition and lower it to more than 5%.
Yeah, right.
This is a provision that's been in code for quite a long time.
I'm just concerned, Mr. Chairman, the committee doesn't know what they're voting on. I mean, maybe everybody else is crystal clear on it. I'm certainly not. And I just, you know, it's a.
That's why we're here.
So
I'll trust that everyone else understands this very clearly, because I don't.
All good questions. I just a little bit of maybe can help you just a tiny bit understand a little bit more. If you go look at Section 5 of your bill, that's current law. That's what THC is now, and THC is considered a Schedule 1 substance, and that's in 1613.25. This definition. When you look at the definition of marijuana, which is in 1613.21, it's not in your bill. It's been in prior versions of House Bill 722, but the words in it are that kind of help you go down this path. Marijuana means all the parts of the plant of the genus cannabis, whether growing or not, the seeds thereof, the resin extracted from any parts of the plant, every compound, manufacture, salt, derivative, mixture, or preparation of such plants, seeds, or resin, but shall not include samples as described in subparagraph P of paragraph 3 of Code Section 1613.25, and shall not include blah, blah, blah. So there's this interplay between the plant of marijuana, the level of THC that's in it, and how you get to Schedule 1.
Does that somehow, I guess the question we would all have is, does that somehow overcome the limitation, the 5% limitation on the oil as per HB1 of last year? In other words, do we have a conflict?
In House Bill 1, we are in Chapter 12, and there is no definition of THC. We have a definition of THC in Chapter 13.
And this bill is replicating that into 12, so that you've got the definition in both places. But I don't think that would be, your question is, does it create a,
Yeah, I think the concern, if I'm hearing and feeling Mr. Setzler, is do we have a conflict as it relates to the percentages and to what is allowable under Georgia law and what is not, and do we have a conflict that could cause confusion later on?
well, we have 3 different substances,
Mm-hmm.
and then we have a gap in between the low THC oil and the THC.
At 5% to 15%.
Right. That's currently in the law.
It would have been there.
Okay, but
even
we
if we
just
wouldn't have
spoke
made
to
a
the
change
oil,
today.
though, last year, and that is the only thing that is allowable under Georgia law, and that is limited to 5. So anything above that is per se illegal, correct?
Once if it's plant material, and they can identify it as marijuana, yes. If it's not plant material, and it tests out at more than 15%, then it's THC.
Say that again.
Okay. If it's the oil, up to 5%, that's
Mhm.
low THC oil.
Right.
If it is still an oil or that type of format and has more than 15%, then it's this definition of THC in 13, therefore it's a Schedule 1.
Okay.
So there's not an inconsistency, there's a gap.
Okay.
So in essence, if it's above 15%, it's deemed to be,
Schedule 1.
it's
And
not
illegal.
pure THC, but it's deemed to meet the definition of this is THC.
Correct. If it's not in plant form.
And there's no circumstance here where the 15% is says it's okay to have this. Its definition changes and takes you into a whole other part of the code with respect to what you've got. You've got a Schedule 1 substance, and you're subject to federal law, I guess, presumably.
Well, we've got code sections that regulate the possession of Schedule 1 substances over in 13. So this request to change the language is coming from the crime lab and based on what they find in the substance when they test it. We've replicated the language here in Chapter 12 because we use the term.
Okay. Mr. Reeves. Mr. Atwood.
Yeah, I'm a little tired. Forgive me. 5% is what we approved last year, correct?
Yes, sir.
And I believe the testimony last year was you'd have to drink about 2 gallons of this stuff to get high, get into layman's terms, correct?
Drinking,
That's correct.
that's
Okay.
right.
Or, well,
And so with
or
this
get a bad case of
particular,
diarrhea, one or the other. Yeah.
That's it.
Yeah.
so with this
Mhm, yeah.
particular bill that we're all going through several iterations of this thing. What we are essentially authorizing people to do is bring low THC oil into Georgia. Is that correct?
Well, if I were to go, or any citizen who was properly registered were to go to Colorado and bring it back, they're still in violation of federal law when they
I'm talking
transport
about
it across
under-
state lines.
Under state law.
Under federal law.
Yeah.
Under federal law.
No, I know that. I'm saying that we're authorizing it to be shipped in or mailed in they will not be in violation of state law.
That is correct, as well as the manufacturer who is shipping it would not be in violation under state law.
And we're not authorizing any, pardon me, Mr. Chairman, but I'm trying to speed this up. They're not authorizing anything else other than low THC oil, which is essentially what we approved last year. And we're adding some additional maladies that people have, correct?
And one additional cannabinoid, THCA.
Okay. That's the part I'm confused on.
Okay.
Could you help me?
Okay, so that's where the crime lab comes in. They come to us and they say they see THCA in a substance that was either extracted from a live plant immediately thereof or while testing from a live plant. Once that substance gets heated or ingested in the body and mixes with the acid of the stomach or whatever, then that becomes THC. And from a laboratory testing standpoint, if they find either or both which is what they find, then they need that definition clarified so that that's what the report accurately says. So this doesn't change the substance that they've been testing all along. It just brings code into line with what they actually are capable of extracting and seeing in a crime lab test, is my understanding of the problem. I understand how the non-lawyers feel when they come into this committee room when I'm trying to do chemistry as a non-chemist.
You do pretty well.
Mr. Coomer? No. Mr. Atwood, did you have follow-up or no? I'm sorry.
Is the hallucinogenic effect, forgive me, that's the only term I could probably use, the psychoactive effect of the acid and that sort of thing that Mr. Speha spoke to, is it any higher or any greater than what is being that's in the cannabis oil?
In fact, the THCA, there is no psychoactive effect whatsoever because it has not been heated. It has not been debunked. I'm not pronouncing that right. Right. And so that's why I was comfortable adding it and would ask the committee to continue to include it because it's been seen to have significant evidence, like CBD has for a lot of these children, particularly with seizure disorders. If you remember the one family that came before this committee, the grandmother whose grandson, Trip Oliver, was still in Colorado. They were not able to come back because THCA was technically not allowed under Georgia law. And so they and several other families saw that THCA was a better benefit for them than the elevated levels of CBD and low THC. And so that's why we have included in this year's bill. I know it's complicated. I'm not a chemist either. But that's all we're doing is adding another cannabinoid to the list of that's allowed under Georgia law. It is not psychoactive in any way.
Okay. Thank you, Mr. If I could say one other thing, if I do pass, if I vote for that, it doesn't necessarily mean I'm going to vote for it on the floor.
Okay.
But I may very well encourage or at least be willing to give this thing a vote.
I would love to get your yes vote out of this committee, Mr. Atwood. Thank you.
Mr. Sutton.
Thank you, Mr. Chairman. I do have two other quickies. Well, we'll let the author determine how quick those go.
Okay.
I just want to confirm there's no change in the bill here with respect to drug-free workplaces. I know there's some discussion in earlier versions, sort of a staying of people's ability to have a drug-free work. But this still would allow, if there was a drug-free workplace, there wouldn't be any ability to kind of force the hand of employers. Correct?
That is correct. There is no change in the existing law that was written into HB 1.
Okay. And one other thing I wanted to ask, Mr. Chairman, on autism spectrum disorder, line 104. I just wanted to say to the author, I had some serious concerns about that earlier when we were talking about virtually unlimited THC. One thing I was sensitive to as we debated this last year is the question of whether we're looking for something to have a palliative effect or something to have a medical effect. Even if we can't put our finger on how it works within one's body, there is a difference between sort of making someone's pain go away through a palliative effect versus it having some chemical, medical, pharmacological, impact. I've got real concerns about autism spectrum disorder because we recognize there can be people very mildly autistic on the spectrum. I think in the context of a bill that keeps the THC at 5%, it's THC oil only. I don't have as much of an issue because I've heard some discussion around it being helpful. I would say, though, I know this is a process, and I know you've got an expectation of moving this legislation in future years in different places. I would say, though, when you talk about autism spectrum, if you're talking about taking, in the future, a move towards a THC level of being 60-65% in a paste or an oil for someone that's on the autism spectrum, I think it's a very, very different thing. I don't know that the pharmacological impact of THC, THCA, CBD in something we don't fully understand yet is going to solve that issue. I've got some concerns there. The same concerns I share, Mr. Chairman, about the intractable pain.
Well, I think, if I may, to the author, I mean, I think that's what the beauty of this process, going back to HB1, is that ultimately, yes, it's in the realm of possibility as per this body should, survive the process, and I hope it does. But ultimately, the medical professional is making that determination through the process that we, went ahead and built last year. So if we're going to err, I'd rather err on the side of breadth rather than narrowness, because I know that I have that safety blanket, that safety net, that fallback position of it's a medical professional making that determination, that recommendation, rather than a bunch of laymen like us.
Mr. Chairman, and the only reason I made the point to the author, and I just shared the committee, is to the extent there'll be something that's before this General Assembly in future years, I don't have an issue. And I'm just speaking as I've tried to analyze this, not just personal feelings. I've tried to be analytical about this and try to segment things and call them what they are and be intellectually honest about them. Things like autism spectrum disorder, even though they might seem perfectly fitting on a list with low THC oil, could be something fundamentally in conflict with the concept of what you're doing at high THC levels. Even though it might not stick out now because we're talking about low THC oil, when you're raising or making a THC limit almost as high as you can make it, there are things like this that will stick out, I believe, as outliers in the future. And I raise it to you so it's not a circumstance where in the future we'd say, well, hey, we already covered autism. That's already on the train. That train's left the station. Let's move on. Well, if we start raising THC levels, then you start to, I think, impugn the credibility of things like autism disorder and other things. As you make those moves, it becomes a complex mix, I think, when you analyze it.
But of course, we're not going to be looking at that in a vacuum. I share the gentleman's concern, but I know we're not going to be looking at that in a vacuum in future years, and we'll be taking a very holistic look at it.
Appreciate the chair's indulgence.
Not at all, Mr. Gravely.
Thank you, Mr. Chairman. Just on the gap, so as I'm trying to think about it, or based upon the definition, the 15%, so did we give immunity last year in HB1 where immunity was not needed for the 5% oil? If we're looking at containing more than 15% by weight of the THC or THC, now we're adding THCA, but so just correct me if I'm wrong. I just wanted that popped into my mind was, did we give immunity?
Well, prior to HB1, you had two different substances. You had the marijuana plant, and you had THC if there was 15% or more present in there. Otherwise, the substance wasn't covered by code.
So we did, didn't we? Where immunity wasn't needed.
It's covered now.
A pregnant pause, if there ever was one, I think.
I guess the question would be, Mr. Chairman, if you don't mind, I mean, if an individual had low THC oil or had medical cannabis oil at 12% THC, they would technically not be in violation of Georgia law.
It is not covered by code. Do you agree, Ms. Travis? It is not covered by current code.
Thank you. Follow up, Mr. Chairman.
So there's actually a gap between the 5% and the 15%, such that you're saying that there actually is no prohibition right now under Georgia law for the gap between 5% and 15%.
6 to the 14.9 or whatever.
Technically.
Good information.
And even prior to that. If I may follow up, Mr. Chairman.
Please.
To the author, I just want to say how much of an honor it has been to work with you, to watch your passion firsthand for these families. That's been something that I'll take with me for the rest of my legislative career. And I really, I think, appreciate the time, the willingness to meet with everybody, both pro and con, on this legislation, to try and craft something. I, too, am disappointed, but I think that, as you said, you'll be back and others will be back, and I look forward to continuing this fight with you, if the Lord allows. But I did want to say that how much I appreciate you as a friend, as a mentor, and as somebody that I can was able to go on this journey and look forward to continuing on this journey with. I appreciate you very much.
Thank you, Representative Galley. It's been my honor to be with you.
Mr. Pack.
Thank you, Mr. Chair. Getting back to the language of the bill, on line 78, this question may be for Legislative Council as well. I know this section allows shipping, so it gives kind of indirect immunity for manufacturers and also the recipient. Question is shipping, is that a defined term, or would a term like transport be better? Because when you ship something versus transporting something, I think there might be a distinction. Secondly, are we not granting, I guess, state immunity to places like UPS, I guess, who's actually going to do the transporting of the goods?
As far as I know, shipping is not defined. It would be what the dictionary definition is, so certainly we haven't defined it here. I don't have any heartburn about transport.
Or transport? I would imagine that some shippers will probably have some heartburn about a knowing manufacturer is shipping that to an entity, but okay. Is transport defined? I don't know. I was trying to look it up, but it's not coming up.
Well, if it was, it's not going to be, you can't carry it over if it's in Title 32 for highways and stuff.
Right.
It doesn't have the same meaning here. Only has the same meaning here when we define it here. I don't have my functional manuals with you to give you the ordinary meaning that the code would give it.
Mr. Schwehouse, do you know if in Title 16 if there's anything related to that?
I know based on our conversations and looking at Title 12, I'm almost confident that it's not addressed in there.
You mean chapter?
I mean Chapter 12.
Yeah, I think I'll look at 16.1, but I'm pretty sure
Right.
it's not defined for the title. And I know it's not in 131.
The only thing I would address with that, your second point, was the issue was to provide immunity for manufacturers. And if we get into the actually shippers, the person actually transporting, that was, we really didn't try to address that. We wanted to encourage manufacturers who were potentially in violation of federal law. Would you be willing to ship it, challenge the federal government possibly, as long as we provided you immunity? I think that, Mr. Chairman, would you agree with that?
I
Mr.
want to be
Cameron?
careful to say that we're not encouraging or discouraging.
Right,
We're
right.
worried about what we can control.
Right.
And what we control is state law.
Right.
So that whatever decision that a manufacturer may make in terms of its conduct,
It's their decision.
it's
right?
their decision. We can't look at it in a vacuum. We'd have to look at it. I think universally it's going to get looked at in the context of, is there federal enforcement at this point?
Right.
Everything we see that there's very little, if any. The Congress and the President have made a very affirmative statement on that as to where they're going to put that priority. But in terms of encouraging or discouraging, I personally would not want to characterize that. I would just want to look at it in the context of what our jurisdiction.
Right.
Can I ask just a quick follow-up from before? The 5-15 issue is, I think it's important to understand out loud where we are. Does the bill fill the gap between the 5 and 15?
No.
It does not. Okay. Vice Chair, I'm sorry. Did you have a follow-up?
No, and I want to make a little statement. Thank you so much for your efforts in this, Representative Peake. As you know, this is my last term here.
Yeah.
And I hope that you continue in your advocacy for providing a solution that only you can partially provide at this level. Thank you.
Thank you, President Pack. We're going to miss you, too.
Mr. Sessler.
Hey, Mr. Chairman, I wanted to ask this to PAC. Hypothetically, let's say that I had a constituent that needed to have low THC oil, and I decided to get on a plane and go to Colorado and get an appropriate amount under 20 ounces and bring it back for them. I know that's not something I have planned, but I know that's not unprecedented. And THC oil comes back. I provide it through some series of circumstances. It comes out that law enforcement finds out that said oil is 12% THC. Now, and they say, wait a minute, this is in excess of 5%. You're allowed 5%. What you have is 12%. So I would promptly go get two dynamic defense attorneys, a team, one from Douglasville, one from LaGrange, to be my defense counsel, and I'd go before the prosecutor and say, wait a minute, this isn't THC oil that's over its limit. This is simply a THC sample that is comfortably under the limit, and can be that can be shown by an independent lab and by a GBI lab. Am I guilty of exceeding the 5% THC oil level, or am I just on its face under the limit and within Georgia law?
I think it's a substance not covered by law. The 12% right now.
Well, no. As a prosecutor, would one of your prosecutors not insist? I mean, if it looks oily, feels oily, it says oil on the front, is that not oil that's in excess of 5%?
No, I mean, it depends on what the crime lab tells me it is. I mean, I've got to travel on the evidence I've got. If I got a crime lab report back that says it's 12%, it doesn't meet the definition of either of the two substances that we've discussed.
But if the substance comes in a small vial and it says something oil on it, you take it out, you put it in your finger, it feels oily, it's oily to the touch, it looks oily, it's golden color, and it's by any definition oil. And it has 12% THC in it, and that's ironclad. Am I in violation of the law because I have 12% oil, or is it simply a sample of THC that falls below the limit?
Right. Our definition of THC would not be included in Georgia's definition of THC.
So functionally, our definition is 15% under this bill and existing law versus what the 5% that's been discussed. That's certainly my defense attorneys would argue that, and what I'm hearing from you is a prosecutor couldn't hold me to anything but the 15.
But is the 14.9%, we'll call it, is the 14.9% of medicinal value?
Yes, absolutely. And in fact, Mr. Chairman, there could be an argument, as we've discovered this, or as I've discovered over the last 24 hours, that we could take the current law of low THC oil and move it to 14.9% and still be under what's under current law and provide protection for possession for citizens that are properly registered. Is that not correct? I mean,
the legislature's got the authority to do that. We haven't heard any evidence about going either way with it, because I'm going to be honest with you, I don't know where the 15% came from. It's been in code for a long time. And so without talking to the crime lab about whether we should go one way or the other, I would caution the committee to let us get somebody that knows what we're talking about involved in that.
Is if the 14.9 has medicinal value, does it have hallucinogenic property as well?
There is potential that it would have some psychoactive effect. But again, I would argue that it's not much more than Oxycontin or hydrocodone or drugs that are already out there available to citizens.
Okay.
And in fact, I think there could be an argument made that maybe we ought to go ahead and match it up with where we are in state code to the 14.9 or 15%, what's the best way to define it. And
Mr. Chairman, I asked the question because I think we ought to either be all at 5 or all at 15. Now, I may land in a different place on that than Representative Peake does, but I raised the question because I think there's got to be clarity on it. And I think our legislature thinks we're at 5, and I think we're not at 5. That's my question. And I personally think it ought to be the policy to be at 5. If we're moving to expand the number of conditions, as this bill does, and I think we all think this is a bill that's coming to keep us at 5, I think it's this committee's job to get clarity in that and consistency in that.
And, Mr. Chairman, if you will, I would actually argue the exact opposite, that if it's in 15% in current code for who knows however many years, and that's what the learned prosecutor over here has said they've worked with for years and they've been comfortable with that. Why wouldn't we go ahead and move it to 15%?
And again, they've been comfortable with that as a threshold when you have necessarily, I mean, no substance is completely pure. I mean, the gold in my ring is not 24 karat gold, but it's the definition of what a gold ring is has a definition. So the definition of what THC is always a relatively low threshold, because if it's in a matrix, it's in a mix, you had to be able to prosecute it in the past. So it wasn't 15. It wasn't at 15% low these years as a valid substance that one could consume. It's just a low threshold that's way below 100%, so that they could prosecute it and get convictions on it. That's why it just has happened to be there. The policy question before us, though, is maintaining it at 5. And I think for consistency, we need to have that. There's no latent legitimacy behind the consumption of 15% THC. That's only been there as a means of having a very low bar so that we can get convictions. So I think I don't want to conflate two distinct terms.
No, I see the back and forth, and it's a good conversation. What's the cutoff? I mean, our whole justification on 5 last year was that there's no psychoactive effect, but there is medicinal effect. We go to this 15. Obviously, there is psychoactive effect. What is that? What is that line where we, potentially some conditions will call for a higher THC level because that condition warrants it? But obviously there's a concern regarding the psychoactive effect of that particular medicine, and that's my sense is that it's the sense of the General Assembly and the executive that they don't want to go into that and get into that territory. And so the question is, from a scientific standpoint, which my sense is we're not going to solve today, what is that number?
Well, it may offer this.
Or percentage, I should say.
You correct me if I'm wrong. I would say that, and what I've been told from the folks that I've been in the industry, is that if you go to buy a joint on the street, it could be anywhere from 12 to 30% THC. Okay, so what I would maybe offer today to the committee is, in the wisdom of Solomon, let's split the baby. If most street marijuana that somebody's going to go to get high is at 12% on the low range, why don't we say that we go at 10%? We move the 15% that's in current code to 10%. We move, and therefore be consistent.
Here's where I'd like to go on. I mean, I appreciate where you're coming from on it, and the side you want to err on. I think the committee will do well to press pause and to have some consultation with the crime lab people at the GBI, and to figure out where that is from a purely objective, dispassionate, disinterested, standpoint, just the facts. Okay. And I think we would do well to go ahead and have those conversations between now and Wednesday to make sure, to Mr. Setzler's point, and it's a point well taken, that we're comfortable as to where we are and where we're going with full knowledge of what it is. That doesn't mean that we won't consider an alternative. It's just that we have to do that with all the facts at hand as we can come to understand them. So, yes, ma'am.
There might come into play here is what qualifies THC for Schedule 1, because that's what we're talking about, and there might be some scientific criteria that is involved.
That's why I wanted to wait and talk to the crime lab.
Okay.
Because I do believe the 15% was established for some reason similar to that. We got to have a bottom threshold to say it's present, and scientific methods have changed considerably during that period of time. So we just need to discuss that with the experts.
Okay. Any further questions from the members of the committee for the author or Mr. Spehaus or counsel? Okay.
Mr. Chairman, can I have one final comment?
Sure.
Thank you to this committee. I know there's been a lot of hot debate about this, and I've had discussions with almost every single one of you about this. Like I said, I'm disappointed we're not moving forward with cultivation, but I respect the will of this committee, and I respect the input and the decisions of you, my colleagues, because at the end of the day, I have to make a compelling argument to convince you. Obviously, I didn't do that well enough on the cultivation piece, but I appreciate your indulgence of looking at language that will continue to help citizens here in Georgia. So thank you.
Thank you. We will meet on Wednesday. We'll finish our consideration of House Bill 72 in preparation for it to go to the floor, and we will be taking up at least one other bill at that meeting. Thank you. We're adjourned.